Okay. And then I'll send it over to Michael to get us started.
All right. So yes, hello, everyone, and welcome. I'm glad you come out in such big numbers. It's still counting. People are still dropping in. So I'm Michael Ladish. I'm the Scholarly Communication Officer at the UC Davis Library. I provide support and guidance on open access publishing, on scholarly impact, and on basic copyright questions, and that's why I'm here. Byron Roberts will introduce himself later. So Byron is have a few slides about patents and embargo questions. And I'm talking mostly about copyright in relation to your dissertation and your thesis. This is gonna be first a little bit of a sort of a copyright mini 101. So just a few basic facts about copyright that everybody should know, and you may know, but you may not know. So I will start with that, and then I go and provide more specific information that will help you to find your way around when you file your dissertation and write your thesis and so on. So first, before I start, a disclaimer: I'm not an attorney. I don't provide legal advice, so nothing that is said here is legal advice. It is just guidance to the best of our knowledge. It will probably help you. It will probably be very useful, but again, it's not legal advice. We are not authorized, or I'm not authorized to provide that. So copyright is a form of intellectual property. There are other intellectual properties, patents. This is something that Byron will talk about, and he's an expert in that. Trademarks, industrial design, trade secrets, and geographical locations. So geographical locations, you probably know that champagne can only be called champagne when it really comes from Champagne in France. So this is the protected area, the protected name. But we're talking about copyright here. There's a law, a copyright law, the Copyright Act from 1976, in effect 1978. It is a revision of the 1909 copyright law. And so this shows you this is not something that changes with every incoming new administration. So this is something that is pretty solid and stays in place, but there are amendments made to reflect new developments in society and technology and so on. It is a federal law, so the copyright law is only will only be can only be prosecuted or pursued in federal courts. There are also state federal laws, but they are less important in our context here. And each country, so to bring an international perspective, in each country has their own copyright law, usually very similar, but there are also differences. But since you are here on the US soil, basically we are all subject to the US copyright law. The copyright law protects the work, original work, by authors, by creators, but the objective is not to reward the labor of these creators. The objective is to promote the progress of science and useful arts, as Sandra Day O'Connor said in 1991 as Supreme Court judge back then. So we protect the work of authors, composers, artists, scholars, and so on, in order to encourage them and provide incentives so that they create more, on which then others can build freely upon the ideas and the information conveyed by that work. There are several works that can be, or that are subject matter of copyright, that are protected by copyright, as long as they are fixed in a tangible medium of expression. That means it's not if you have an idea and you talk to the idea about the idea to a friend, that's not protected by copyright law. If you write the idea down in a Word document, in a letter, or publish it even in a book or journal article, then it's protected by copyright law. So literary works are protected. That is not only fiction or poetry, this is also scholarly literature. This is even source code, computer code. That was when computer codes were created first. It was a dilemma for the copyright office. Well, how do we protect this? Where do we put this in? And because it's written, it's literally written, it's protected under copyright law. It's literary works. Musical works, you're all familiar with that. You cannot just copy a CD, or you cannot just disseminate a song that you like, that you heard on the radio and recorded, because this is all under copyright. Dramatic works, which includes the music, and the music includes also the works, the lyrics, choreographic works, pictorial graphics, sculptural works. So that's everything from photographs to sculptures to paintings and so on. And then, of course, motion pictures, and motion picture companies are very strict about their copyright law. They very pay much attention that no unauthorized use happening. Sound recordings and architectural works. I should mention in a note, I have this note here, beware of layers. So copyright materials can have different layers. So you can have a photograph, which in itself is protected under copyright. But what the photograph depicts, what you see in a photograph by itself, can be a subject of copyright. Or recorded music. So you have the copyright on the lyrics, you have the copyright on the composition, and you have the copyright on the recording. So sometimes it's just one person, sometimes it's 3 different musicians or composers or whatever. So pay attention when you use these kind of material in your work, in your teaching, your research. Copyright can have layers. What's the subject matter of copyright? What is not protected? So I just mentioned what is protected. Not protected are ideas, procedures, processes, systems, and so on. Facts are not protected. Very important. If you go out every day in your backyard and measure the temperature every morning and create a table which shows what the temperatures are over a period of time, that's not protected because that's a fact. Temperature is a fact. You just record. If you put this in context, if you interpret the data, if you put it in relation to the environment, put it in relation to your backyard settings or whatever, then it becomes protected property. Not the fact again, but the interpretation of it and the work that you provide there. Words are not protected, phrases, familiar symbols, titles, book titles or movie titles, but also be careful, Harry Potter and the Sorcerer's Stone is protected because Harry Potter as a fictional character is protected under copyright. Sorcerer's Stone not, so you can create or you write a book that's called the Sorcerer's Stone, you wouldn't have a problem with that. So that's why you also have movie titles that or you have different movies that have the same title. So like The Revenge or The Two Lovers or whatever. There are several different movies over time that have the same title. So titles are not protected. And works by the US government are not protected. That means by US government employees. So the NIH, Department of Energy, and wherever they all have researchers, they have they put out brochures, they put out policy documents or whatnot. They are not protected by copyright. And then works in the public domain, they are also not protected. I just forget to mention in relation to facts, there was a Supreme Court decision in 1991 where Sandra Day O'Connor actually provided this quote that I had a couple of slides ago about the telephone book. So a company copied the telephone book from a telephone company and wanted to sell it, and the original telephone company sued them. And the Supreme Court said, no, that's not copyrightable. A telephone book is just a collection of facts, of data. There's no intellectual work done except to put them in an alphabetical order. And so therefore it's not protected by copyright. That's why I have this image here. So public domain is not protected. Just to explain what public domain is. So this is work that is not protected by copyright because copyright has expired. So everything published before 1925 is not protected by copyright. Or the copyright owner failed to follow copyright renewal, but this applies only to older works from the 60s and to 78. So it's not as relevant here in our context now. Or the copyright owner deliberately placed the work in a public domain. So this is also something that they can do. And then again, US laws and government works are in the public domain and not protected by copyright. But publicly accessible does not mean public domain. So don't mix these two terms up. I see that my screen is sometimes freezing and sometimes in a very unflattering position. So sorry about that. Hopefully you can hear me and as I know that my speech is not interrupted. This is just the screen that stops. So once again, publicly accessible does not mean public domain. So whatever you see on the internet and websites, much of the stuff is protected by copyright until it is not explicitly made publicly available, open access available. But this is not public domain. This is really something else. So copyright has a duration. So it's not forever, just for a very long time. So the Copyright Extension Act in 1898 extended it to the life of the author plus 70 years. So 70 years, the author has to be dead for 70 years until the work is available for free and not protected under copyright. For corporation, it's even a little bit longer. This was originally shorter, 50 years, but in the 90s, the Mickey Mouse cartoon, the character, which was protected under copyright, was the copyright was almost expiring. So Disney and other studios followed then, of course. They liked the idea, lobbied Congress to extend the copyright, and that's why we call it the Mickey Mouse Protection Act. It's extended now for 120 years, 95 years after publication for corporations. The character Mickey Mouse, the copyright on the character will expire or is expired last year, I think. But it's only the iteration of it. So the character as it was drawn back then, the character itself changed slightly over the years, and then new copyright protection kicked in. So that's the duration of copyright. And so then the question, what does a copyright owner actually gain? What are the rights of the copyright owner, the exclusive rights in copyrighted work? So only the copyright owner can make copies of the work. Only the owner is allowed to do this. Of course, the copyright owner can license it to other people, other companies or whatever to copy it. The copyright owner also may transfer the rights to somebody else. This is mostly the case, or very often the case, when you publish a scholarly article with a journal, then the journal asks you to transfer the copyright. So the journal has the copyright. And you can avoid this by publishing open access, because then you retain the copyright, but this is a different presentation. So making copies of the work as the exclusive rights, make derivative works based on the original work. So derivative works are a translation in a different language, abridgments, dramatizations, audio versions. So it really depends on what you can do or what may be possible to do with a specific work. You can only the copyright owner can distribute the work, perform the work, if it's performable, display the work for photographs, for films, for paintings, and so on. So these are exclusive rights that the copyright owner has, and only the copyright owner can do it or can license it with companies or other people. But there are some exceptions, and thank God we have these exceptions, because without them we wouldn't be able to use anything that is being copyrighted and available, but would not be reused without permission. One exception to the copyright is the fair use clause. And the fair use clause allows people to use a copyrighted work without permission by the copyright holder. You don't have to ask. But certain factors need to be evaluated and need to be positive in order to use this work without permission by the copyright holder. There are four factors, as we call it, 4 factors of copyright use, of fair use. The first one, this is always leaning towards fair use. This is the purpose and purpose and character of the use. It's always leaning fair use in the context of research and teaching. So if you want to use a work without the permission of the copyright owner for teaching, for comment, for scholarship, for research, that is a good fair use argument. The second, in addition to that, it should also be a transformative use. So if you use a work in a different way than it was intended as it was created, then this is leaning towards fair use as well. So in other words, if you have take a poem and you have an English class and you want to analyze this poem, you can certainly copy the poem and can distribute it in your class, because you analyze it. You don't just read the poem for the sake of it, to enjoy it. You actually do something completely different. You analyze it. It's a transformative use of the material. It's a non-consumptive use, as we call it. So the second factor is the nature of the work. This is the least important factor for fair use usually, because it's more about the form or format of the work. So it's published versus unpublished. So published work usually is much more protected or is leaning against fair use. No, the other way around, sorry, apologies for that. Against fair use is the unpublished work, so writing, letters, or whatever. If it's published, then the fair use clause might be more, could kick in here and could lean more towards fair use. But again, this is the least important factor. The third one is the amount and substantiality of the portion that you want to use. And this is something where I get often questions, or we in a library get often questions and asking, so can I copy 20 pages of a book, or can I copy 10% or something like this? And the copyright law doesn't have any red lines. The copyright law, the fair use clause, don't have any numbers in there. you should and you could use as much as necessary to make your point, to make your argument, to demonstrate what you want to demonstrate, use as much as it's necessary for the purpose that you're using it. If less is always better, so the less you use, the better it is. But there is no hard line of a percentage or a specific number of pages or character or chapters and so on. And in some cases, you actually have to use the full work if you talk about a photo or a painting or a poem, for example. Then it is the full work would be used. So it's not absolute that you can say only a small portion is protected or leaning towards fair use. Sometimes it is also the full work, really depending on the purpose and depending on the work itself. And then last but not least, the fourth factor is the effect of the use upon the potential market for or value of the copyrighted work. So here, the most obvious example is if you copy a textbook for your class and distribute it to your students, students will be happy probably, but it's a total infringement of the copyright because the impact on a potential market is big. The publisher wants to sell this book, the textbook, to the students, and if you distribute copies of it, it obviously has a big potential, a big impact on the market. So these four characters all should be taken together into account when you assess if a work that you want to use for teaching, for research, or for other purposes, if you can use it under the fair use clause without permission by the copyright holder. Not a single factor alone is here the deciding factor. So you really have to look at all four of them and then make a informed judgment, basically, and decide, okay, this might be covered, this is probably covered under fair use. I can use it without permission or not. If you in doubt, then don't do it. The fair use doctrine is really our best friend here in academia, because without it, all copying for any purpose without permission would be infringement. So we couldn't do anything really. There are a few other exceptions to the copyright law. Fair use is the most significant there, but we have an exception for libraries, so we can copy material for interlibrary loans, send it to users in other libraries and receive it. We can make copies for course material, and there are exceptions for people with visual impairments, for example. They can create audio versions and so on. But again, fair use is the most significant. The fair use clause is intentionally vague, so that can be sometimes frustrating. I hear this, I get questions from users, library users, from students and faculty, and say, what should I do now? Can I use it? Can I not? And I say, I don't know. It's your decision. I can only look with you at the four factors and say this is leaning towards fair use and this is leaning against fair use, but it's not. It's a decision that the user of the copyrighted work has to make. And sometimes it's not an easy decision. I acknowledge that. There are no quantitative limits, as I said, no absolutes. So there's a rather sliding scale of four considerations. And it's up to the user to consider these four factors, said this already. So no one factor is deciding, and every case is different. So for authors, just brief advice, apply the four factors if you can. Leaning towards fair use when copyrighted material is used for criticism, commentary, discussion. when the material is used to support or prove an argument or a point, and if it's non-consumptive research, as I said, so copying works for the purpose of text mining, for example, is covered under fair use. You should make sure that the amount that is copied is reasonable for the analytical purpose, so don't copy more than you really need to, and that the material is not used as decoratively or to entertain or for whatever, but really for analytical purpose and justified for that. And always give attribution to the author of the material. This is almost a no-brainer, but this is something you need to do and you need to pay attention to, because otherwise you get into the plagiarism area. You don't want to touch that. So reasonable attribution should be given to the author of the material. And the Authors Alliance is an organization, non-profit organization, that provides very interesting, very helpful material for free for authors, mainly academic authors. So this is a little brochure about the fair use clause and explains a little bit more and a little bit better than I do, and in more details with examples, so you can download it for free. They also have other very good brochures about author contracts, for example, and use of AI and so on. Of course, the author, the copyright owner can make this material that they have the copyright for available to the public by either licensing it to somebody who's then selling it, or by providing a Creative Commons license. And Creative Commons licenses are licenses that the copyright owner attach to a work in order to make it open access, to make the material publicly available and accessible for free. The copyright owner keeps the copyright, so it's not a transfer of copyright. It is really just a license to reuse the material without any payment, without any permission or whatever. So if you see this Creative Commons sign icon somewhere, CC, you're safe, you can use the material. Fair use doesn't even apply here because the author or the creator of the work gave permission to reuse the work without explicit permission or applications or so on. The Creative Commons licenses are usually attached to the open access publication that many of our authors, you probably included, many of you, publish under our open access agreements that we have with publishers. They all are published under Creative Commons license. So the author keeps the copyright, but other people can reuse the material for free. And they have several levels here. I don't want to go through all of them. Just the main one maybe is the people are most concerned about is the non-commercial purpose, for non-commercial purposes only. So the CC BY NC allows other people to reuse this work without permission, without question, but only for non-commercial purposes. So that's a restriction that a lot of authors, a lot of copyright owners apply. So, but if there's no Creative Commons license, and if fair use doesn't really work, so what you're gonna do, you really want to use this graph, you really want to use this image in your dissertation or in your article and so on, then you can, of course, obtain permissions. Of course, you can contact the copyright owner. First, you have to identify the owner. Sometimes very easy. Journals always, or books, they always have the copyright printed somewhere and with the copyright owner. In older works, that might be a little bit more difficult, or pictorial works, photographs and so on. You need to identify the copyright owner, and then you can send them an email. That's all you have to do. There's no standard application form or something like this. At the bottom here, there's a link to a template from the University of Texas that tells you what such an email should include. You ask for permission to use this material. You state what your purpose is, where it will be published or where it will be used and for how many copies and so on. So there's many details as possible. And then the copyright owner can write back and can say, oh yes, I'm happy to use it, go on. The copyright owner might also reply and say, yes, but you pay me $30 for that. You pay $30 or not. Some copyright owners, big publisher, charge more for that. It really depends on what material you are talking about, what material you want to reuse, the amount of the material, and so on. So each case, again, is slightly different, but be prepared that copyright owners might ask for a fee. Yeah, so the request of permission, the writing should include the identification of the material and the link to it and so on, nature of the use. So what if the copyright owner is unresponsive or says, I don't want you to grant the right, or I charge you something and you don't want to pay this? Then you can look again if there's a fair use option. So that might be a way around. Or you simply can't. You need to use alternative material. Sometimes it's simply not possible. If the owner cannot be identified, that also happens sometimes, especially if it's older material that is still under copyright protection. We call this orphan works. So we have quite a collection of the stuff in our library. So these are books published by publishers that own the copyright, but the publisher is long gone. So nobody knows what happens to the company and who took over, or if any. So that is really a more difficult decision to make. Again, you can check for fair use. You can take the risk and demonstrate that you made a reasonable effort to identify the copyright owner, but you couldn't find them. Or again, you use alternative material. So now we are getting a little bit closer to home and also to your dissertation, to your thesis. The University of California has a copyright ownership policy. Actually, it has two policies. One is the ownership of course materials, and one is copyright ownership in general. These policies are in place for the copyright ownership policy is, I think it's a revised policy from 21. There was one before, but this is a newer one now. Course material is longer in place. And what they basically say is that scholarly aesthetic work created by academic authors using independent academic effort are the copyright of the author, period. So anything, any manuscript that comes out of your research that you want to submit to a publisher for book publishing or for a journal article publishing is your copyright to begin with. You can then, or sometimes you have to, transfer the copyright to the publisher. It depends on if you publish open access or not. But at the beginning, you are the owner of the copy. You are the copyright owner of the material. Course materials and student work. I leave the personal works, that's a no-brainer. But student works are also owned by the creator of the work, by the student, by the instructor. So this is slightly different in other institutions, but UC Davis has this policy. So you are the copyright owner in most cases. So who's not the copyright owner? These are folks that are employed by the university for a specific purpose and create work that was works that acquired that they are assigned to. So, for example, we have a designer in our library who's designing like all kinds of, well, graphs and signages and whatnot. And he comes up sometimes with brochures that are really nice. He's not the copyright owner. That's the university, because he is employed for that. This is his job to create this work. We could also, the university sometimes commission work. They hire like an outside filmmaker to make a little movie about the graduation ceremony or whatever. Then the university signs a contract with this movie maker, with the director or cameraman or whatever, and usually keeps the copyright for the university. So these are the two main groups of work. The other things are probably, I don't want to go into details here in the interest of time, but usually you are the copyright owner. So should you register your copyright? That's a question that I also get sometimes. And this is something that this comes up when you file your dissertation thesis, because ProQuest asks you if you want to register copyright, if you want to use their service to register your copyright. Always say no, because if you want to register your copyright, do it yourself. You can do this. The US Copyright Office, it costs $35, I think. ProQuest charges way more, so they do the same thing just on behalf of you. So that not necessarily. The registration is not necessary. It's not totally required. So you are the copyright owner the moment the work is fixed in a tangible medium. But if you want to sue for infringement, for example, then it's better to have your your material registered, because the result of the judgment at the end might give you a better monetary value back. So to protect your copyright, register it if you want to. And it always depends also what material it is. If it is just an essay that you wrote in as a class assignment, you might not go through this. Dissertation, you can, it's really up to you. If you write a book and it's open access and you own the copyright, you should register, of course, yeah. You can also, for course material, for example, for instruction material, you can put a copyright notice on it and then keep track and keep the copyright for yourself. Oops, the wrong direction. And now for something not completely different, but slightly different. Because I work with Sarah and her team several times a week, almost, I would say, helping people to find their way around what happens to your dissertation and your thesis after you file it. So here's a little workflow graph. So you file your dissertation, it goes up to ProQuest, it will be sent to ProQuest. ProQuest puts it up on their platform. But there it is only, not only discoverable, it's only accessible to ProQuest subscribers, because ProQuest is a for-profit company. This excludes, of course, everybody who doesn't have a subscription, or every institution that doesn't have a subscription. So the UC, was a big advocate for open access publishing and open scholarship in general, came up with the UC policy on open access for thesis and dissertations a few years ago. And now there's a contract with ProQuest. ProQuest gets a whole batch of theses and dissertations every quarter, I think. They add more metadata to it and then send a copy of it to eScholarship. eScholarship is the institutional repository for the University of California, and each campus has its own instance there. And in eScholarship, the dissertation will be available to everyone at no cost and open access. E-scholarship is indexed by Google Scholar, so it increases the discoverability of your work, and we encourage everybody to do so. But there might be reasons to put an embargo on your dissertation thesis. And Byron is talking about this in now, I guess, like 2 minutes, because then I'm done. To put an embargo on a dissertation, and this will be honored by ProQuest and eScholarship. The files will still be sent ahead to ProQuest and then to eScholarship, but in the metadata embedded is the embargo end date, and only when this end date is reached, then the dissertation will be switched on and the full text will be available. Users or people will still see the citations or your name and the title and the abstract, so they know the dissertation exists, but they cannot see it and cannot access the full text. And then we get questions from former graduate students, for people who actually have filed their thesis and their dissertations already, who want to extend their embargo. Embargo can be from between half a year and 6 years, no longer than 6 years, or if it's 6 years, you need special permission and approval by the Graduate Council. But the workflow is that the author contact Graduate Studies, and the author fills in a new release agreement with the signature from the major professor. The author also contacts ProQuest and says, hey, hello, I want to extend my my embargo, and I have approval from Graduate Studies. Then ProQuest is doing this. They're relatively quick doing this. And you also contact me and ask and tell me the same thing. I contact the folks in eScholarship, and they implement the embargo extension as well. So in this case, ProQuest doesn't send the information to eScholarship. It's only for new for new dissertation. I think that's it now, because now I think I hand it over to Byron. I'm looking a little bit of the time. We want to allow for question and answers. Whoops. So am I still here? Yeah, okay.
I'm gonna just share my screen to make sure I get this right. Okay, are you seeing the actual slide, or are you just seeing presentation mode?
We can see your next slide as well. So
Oh, okay, that's not what I wanted to do. Let me try something else here. Give me just a second. Let me activate presentation mode, and maybe I have to go to it from. Oh, that's weird. Okay, I think I just shared the wrong. Well, no, you think I've done it enough times over the years to get this right. Apologize for that. Okay, let me share this other screen. Application window, that's probably what it is. Okay, share that. And now hopefully. Okay, are we seeing just the slide now, or is it still?
I can still see the other slides, but
It's weird. There's only two things I can share, and neither of them are working here. Oh, maybe I didn't. Let's see that I stopped sharing. Let's try this. Are you still seeing just the next slide also, Sarah?
yeah.
Okay. You know what? I'm just, because we don't have a lot of time. I don't know why. Usually I get this sorted out the second try, but I apologize. There's only a couple of slides. Anyway, so anyway, my name is Byron Roberts. I'm one of the senior intellectual property officers in the tech transfer office. Our office handles quite a different things on campus in terms of intellectual property. We spend a lot of time protecting patentable inventions and licensing patents for inventions that are created at the university. My office, this will change sometime soon, but my office historically has handled quite a bit of copyright licensing as well. And for a couple of years, I was the quote unquote copyright officer for the campus. And so Michael and I have collaborated on some other things in the past. Similar to Michael, so I'm not an attorney. I am registered as a patent agent to practice before the U.S. Patent Office, but this is the information here is solely for informational educational use. None of this constitutes advice, and none of this can be used to create a practitioner-client relationship. I always have to just get that out there, even though it's unpleasant to have to do so every time. So I only have a couple slides again. So Michael spent quite a bit about time talking in a lot of detail and all good stuff about copyrights. And I'm quickly going to talk about patents and inventions, and because I wanted to tie that back into the embargo process and some things to keep in mind. So briefly, for folks who've not been involved with patenting anything or inventions before, patents are things. So Michael, I think, mentioned that copyrights give the copyright owner certain exclusive rights to do things, represent, copy, use, distribute, etc. Patents are a bit opposite. So a patent owner or the licensee of a patent right has the exclusive right to, or maybe not exclusive, but has the right to exclude others from practicing the invention. And I highlight exclude because if you have a patent on something, doesn't necessarily mean that you can practice the invention, because your invention may actually, elements of it may be covered by someone else's patents. And so even though you could exclude someone from practicing your invention, if you practice the invention, you actually may have to obtain patent licenses from other people for some pieces of the invention. It's a little bit of a non-intuitive thing, but I just put it out there. So patents, and I'm talking about utility patents. There are also things called design patents and plan patents in the US, but utility patents are usually what people are thinking of. Patents can protect basically 4 different types of things. They can protect new processes or ways of doing things. So for example, a new method of detecting a disease or a new method of treating disease, a new method of training an AI model, a new method of doing some task like generating a text or generating speech that uses AI, etc. Those are all ways of doing things. And if they meet the patentability criteria, they are potentially protectable under patents. The other things are more tangible, right? So new compositions of matter. So like new antibodies, proteins, synthetic compounds, etc., are potentially patentable. Articles of manufacture, so things like, small, gadgets or clothes or toys, furniture, those types of things are patentable if they're new. And machines are also machines and systems. So most things that are tangible and most new things that are processes or ways of doing things are potentially protectable under patents. What are not protectable are things like laws of nature. So, for example, the law of gravity is not patentable. Physical phenomena and things that exist or found in nature, like existing proteins and gene sequences, etc., are not protectable by patents unless you change them in a way so they're to a form they're not found in nature. Also, abstract ideas in of themselves are not necessarily patentable, and that relates to mental processes. And sometimes that causes some problems when we're trying to do certain types of software patents, but that's a whole separate conversation. And I wanted to and kind of want to highlight that patents, and there is some overlap sometimes between patents and copyrights. I'll provide an example of that in a moment. But patents and copyrights cover quite different things. So copyrights don't protect the ideas of things, they protect the expressions I have ideas. In patents, they don't necessarily protect ideas per se, but they do protect like ways of doing things, and sometimes that people think of them as ideas. But they actually protect very different types of things. But again, some types of things are coverable, protectable under both patents and copyrights. So here's just one example, and I'm only actually I'm going to go to the second example. These are in sometimes a patent will cover both the like if a method of doing something, but then maybe a tangible thing that does that thing. And this is an example of a patent application that we drafted and filed for an AI invention. And briefly, the invention pertains to certain types of AI methods to basically the background is that there are things called brain computer interfaces, BCI systems, and you can use electrodes to record electrical activity from subjects who have impaired speech or lost the ability to speech. And then there's electrical signals from the electrodes that are attached to the brain or on the surface of the person fed into a computer. The computer does a bunch of processing and synthesizes speech, which is output. And we have patents that are covering those, the actual methods of generating speech in newer, better ways. This is a little bit different. This is actually a method for once you synthesize speech, or once a subject speaks, basically using AI in language models to interpret and provide an assessment of how correct and how intelligible the speech is. And so that was what the researchers had invented. And so the first claim in the patent application is directed to a computer implemented method for evaluating speech synthesized from brain signals. And that method comprises basically 4 different sets: a selecting step, you're selecting a particular speech sequence, the next step of obtaining using the computer processors a synthesized speech signal, C, an inputting step, that inputting that synthesized speech signal into an automated speech recognition model that then generates an output sequence, and then lastly, generating an intelligibility metric. And so that's a sort of broad description of the invention. There are more details in some of the other claims, but that's the crux of the invention. But I just brought this example up because also in the same patent application, so that's sort of the method, the way of doing things, like the sort of, I hate to say abstract, because I just said things that are abstract aren't patentable, but it's something if you could diagram it on a flow chart and absent any particular physical thing, or it's still protectable under patent. But we also claim a system, in this case, a system that contains processors, and those processors, in the system contains a computer readable medium that has instructions, and then the instructions, when executed, they perform basically the method that's that's described in claim 1 up there. And I wanted to mention briefly that this is an example, like software types of things, AI methods are things that are protectable under both copyrights and software. So if you write a new language, large language model is one example, right? And you code that up. The model does something in a new way, right? The way of the doing thing, the new process or the improved process is patentable. But the code itself, the source code that's one example of one embodiment of the idea that's covered by the patent. But that expression, the computer code itself, is something that's covered under copyrights. And so sometimes inventions are both patentable and copyright protected. And so before I get to talk about embargoes, I wanted to bring up the patentability requirements. And so in order for something to be patentable, it has to be eligible subject matter. And I talked about that a couple of slides ago. At the bottom, I mentioned it has to meet what are called the enablement written description requirements. And that briefly just means that the patent application, when you file it, has to have a thorough enough description of the invention that allows others to practice it later on. But the two criteria that are most relevant to here, the theses and dissertations, are the invention must be novel. And novel means that the invention is not available to the public. So if you have an invention, so I just in the previous slide I showed an example claim, right? And we claim the method has very specific steps, right? If all of those steps are described in what we call the prior art already before you file a patent application, the invention is not patentable. There's a 1-year grace period in the US, but most of the world, if your invention is publicly known through publication or other public disclosure, it's not patentable. The other criteria is what we call non-obvious. In the US, they call it inventive step, the rest of the world. And what that means is that even if your invention, like your combination of things, that combination might be new. But if the elements of your invention, the different pieces of the combination, if they were already known in the prior art, the patent office may say, okay, technically what you've done is novel, but it would be obvious, but these pieces of the puzzle were known in the art already, and it would be obvious to combine the teachings of those things to arrive at the present invention. And so examiners will allege that the invention is not patentable because it doesn't meet the non-obviousness requirement. And basically we get that all the time. Many times there are ways to argue against that, but not always. But I bring up novelty and non-obviousness because and the things that constitute prior art, that public knowledge, can be your own disclosures as well, not just what others have done. So your own research articles, presentations, even if you gave presentations on campus, many times they're considered public disclosures. And relevant to this, theses and dissertations, once they are publicly made available, they can be used as prior art against your invention. And we've lost the ability to patent certain things because the theses either weren't embargoed or they were embargoed but too late. So the upshot here, and these slides will be available to everyone because I'm basically at time now, that if you think you have something that's patentable in your work that you've done, and you've not already discussed it with your advisor or my office, and you're thinking, okay, I want to maybe protect it, try and patent, one university might want to patent it later. You may want to consider embargoing it. However, the embargo must be requested before you deposit it, because once the thesis is deposited or published, even if it's taken down later, it will count as prior art, and I've had that happen because we didn't know that the embargo was requested after the fact. It was just folks didn't know as part of the learning process. But also, even if you embargo the thesis ahead of time, you need to be aware that the abstract, I believe, is published, and if the abstract contains enough information to describe the invention, even though the rest of the thesis is embargoed, if the abstract is published and it contains what we call an enabling description of the invention, it can also jeopardize the patent rights. So, if you think you have an invention and you've not discussed it with someone in my office and you're concerned about it, reach out to us and we can help talk about it. But we just wanted to put this out there that it's, if you want to embargo it for this purpose, it has to be done before, and you have to be mindful of the abstract. So I'm going to stop there. That was the last slide, and we're at time, I think.
Yeah, thank you so much. So I'm going to go ahead and stop the recording, and then Michael has said he's able to stay on if folks have a couple of questions.
I can stay on too if needed. Yeah.
Okay, let me stop the recording. Thank you again.